This case is a very important case from the point of view of exams as well as with respect to section 11 and section 40. So basic facts इसके ये हैं कि जो plaintiff यहाँ पर है, he was the owner of a ground and several houses. So the ground and those houses formed a square, and he sold a piece of ground from his property with the condition that the purchaser will keep and maintain the square garden and the ground and the iron railing that surrounds the ground. So the basic condition was कि the purchaser was imposed on with the condition by the seller that purchaser will maintain that square garden and the iron railing surrounding the garden, and then this property through a series of several transactions got transferred to various owners one after the other. So now the last owner, who is the defendant here, purchased the property, and the defendant admitted that he had the notice, because it is very important in this case. So the defendant, when he purchased the property, he was having notice of the fact that the condition was to maintain the square garden and the iron railings. So whatever the covenants in the sale deed, original sale deed, were present, he was well aware of the fact and he himself admitted this fact. But what the defendant wanted, he wanted to change the character and nature of that square garden. So the owners of adjoining buildings of the garden filed a suit for injunction. So the issue that went before the court was whether the covenant that does not run with the land can be enforced, and whether the party shall be permitted to use the land in a manner which is not consistent with the contract. So the court held कि जो कोवेनेंट या कंडीशन यहाँ पर ट्रांसफरर और ओरिजिनल ट्रांसफरी की है, इट विल बी ऑलवेज इन्फोर्सेबल. एंड द सेकेंड एंड द मोस्ट इंपॉर्टेंट कंडीशन रूल दैट कोर्ट लेट कि नेगेटिव कोवेनेंट्स आर बाइंडिंग ऑन द सब्सिक्वेंट ट्रांसफरी with notice. So the second condition, that is कि the negative covenant or the negative condition that he cannot build subsequent structure, or in other words he will always maintain that square garden, is a negative covenant, and it will be binding on the subsequent transfer with notice. Because as I have told, he himself admitted the fact that he had the notice of the fact of the covenant and the condition to maintain that area. So it will be binding on the subsequent transferee. And the court finally held that no one purchasing with notice can stand in a different situation from that of the party from whom it has been purchased. So like the original transferor and the original transferee, so the first transaction that took place, वो जो कंडीशन वहाँ पर इम्पोज हुई थी टू मेंटेन द एरिया विल ऑलवेज रन, एंड इफ एनी वन इज परचेजिंग दैट प्रॉपर्टी with the notice of the fact that he has to maintain that area, it will be binding, and his position cannot be different from the original buyer. And in the exams, if you are citing this case, you can always write down the remark that whatever has been held in this case, that is the ratio of this case, has been made a rule and incorporated in the first para of sex So the ratio of this case has been made a rule and incorporated in the first para of section 40, which is an exception to section 11 and section 14. So basically, for a time immemorial, if anyone is purchasing the property with the notice that he has to maintain or has some obligations with respect to the property, such conditions will be binding on him. And you should always like remember this remark and write in the exams when you are writing this case law.